Welcome to J-Flo History. Today you're about to learn AP Gov's First Amendment Supreme Court cases so you can get that 5. Real quick, the 4 cases we're going to deal with is Schenck v. U.S., Tinker v. Des Moines, Engel v. Vitale, and Wisconsin v. Yoder. But before we get into that, let's do a real quick review over the First Amendment. The First Amendment specifically states, Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of people peaceably to assemble and to petition the government for a redress of grievances. Now, what does that mean in normal English? Well, it means we have 5 essential rights granted by the First Amendment, and these rights include freedom of assembly, religion, petition, press, and speech. So let's get right into our first case, Schenck v. U.S. This is a court case that deals with our First Amendment right of freedom of speech. So some context about the case is that it takes place during World War I, and during this time the U.S. got its soldiers through a military draft that made participation involuntary. This man right here, Charles Schenck, had some very strong opinions against the draft. So strong, in fact, that he wanted to let everyone know. So he dished out these pamphlets urging people who got drafted into the war to not participate, stating that it violated their rights from the 13th Amendment. It would be an understatement to say Uncle Sam wasn't too happy about that, so much so that Charles was arrested under the Espionage Act of 1917, a law that punished espionage, spying, and other related crimes. Pretty much the law said Charles was sabotaging the U.S. military's war efforts. Schenck didn't like that, so he took that issue to the Supreme Court. He argued that him getting arrested for dishing out pamphlets was a violation of his First Amendment freedom of speech. Well, the court didn't agree with him because in a 9-0 ruling, the court sided with the United States. They rationalized that not all free speech is protected under the Constitution. It needs to pass a clear and present danger test. To illustrate that, the court used a theater analogy. If someone were to yell, "Fire!" in a crowded movie theater, they get arrested because that creates a danger to everyone in the room. They are not protected by the First Amendment in that case. So overall, this case shows that the free speech has a limit. No, not that limit. Not that limit either. You get my point. Alright, next case is Tinker v. Des Moines, another court case dealing with freedom of speech. Instead of World War I, however, this case takes place during the Vietnam War. Oh, Lyndon B. Johnson? What are you doing in my PowerPoint? Huh? What's that? The U.S. never specifically declared war, so it was technically a conflict? A conflict that used a military draft too? Interesting. But anyways, here's the Tinker family, and they wore these black armbands to protest the Vietnam War. However, their school didn't quite like that. They threatened suspension if they wore it to school, but the Tinker family still did, and because of that, they got suspended. The American Civil Liberties Union pointed out that what the school did was kind of unconstitutional, so they combined forces with the Tinker family to take this to the Supreme Court. They argued that the school violated their right to peacefully protest and their right to free speech. The school in return argued that the armbands were a distraction and danger to the school environment, making them not protected by the First Amendment. The court, however, did not agree with that, and in a 7-2 ruling, the court sided with the Tinker family. This court case established that symbolic speech is protected by the First Amendment as a proper way to protest, and it also established that a student's right to free speech did not end once they entered the school building. Next case we have is Engel v. Vitale, and this court case deals with freedom of religion, more specifically the Establishment Clause from the freedom of religion. Every morning in New York public schools there was a morning prayer. This prayer wasn't specific to any religion, nor was it mandatory, so it wasn't like the police would just come out and tase you if you didn't join in. However, it was a big pain in the back to opt out of this prayer because you needed a parent's permission slip and all that other information. So the Engel family and others decided to take this to court. It winds up in the Supreme Court, and Engel argues that having school-sponsored prayer violated the Establishment Clause because the school was indirectly establishing a religious activity into their school district. The school argued that since it was not mandatory, it was okay. That didn't convince the Supreme Court, and they ruled 6-1 in favor of Engel. Dang, these schools aren't really good at winning cases, are they? But anyways, this strengthened the separation between church and state. It sort of established a wall between the two. Also, this court case made school-sponsored prayer unconstitutional. For our final case, we'll be talking about Wisconsin v. Yoder, and this also deals with freedom of religion, but this time it is about the Free Exercise Clause. So here's the story. An Amish family, the Yoder family, take their kids out of school after 8th grade. They do this because they believe high school and college is detrimental to raising their child under the Amish faith. Also, they do this because they want their children to learn a specific trade, and public school didn't offer the proper education for that. This, however, violated a Wisconsin law that required students to remain in school until they are 16. This disagreement takes its way up to the Supreme Court, where they heard arguments from both sides. The Yoder family argues that the law violated their exercise of their religion, a religion that has been practiced for over 200 years. Wisconsin argues that school is important for the children, especially if they are thinking about leaving the faith when they are adults. The Supreme Court rules 7-0 in favor of the Yoder family, where they established that religious practices can grant people some exemptions from the law. However, those religious practices must be peaceful, so you can't just go out and sacrifice people and argue that, hey, I was just exercising my religion. That is not excused. So in conclusion today, we learned about Schenck v. U.S., where freedom of speech has a limit. We learned about Tinker v. Des Moines, which said symbolic speech is okay and free speech doesn't disappear in the classroom. Next, we learned about Engel v. Vitale, which said school-sponsored prayer was illegal. A good way to remember that case is that the word Engel sounds a lot like angel, and that's the case over prayers. Finally, we learned about Wisconsin v. Yoder, where we learned that the government can't stop your exercise of your religion as long as it is peaceful. An easy way to remember that case is to see that the case was over a Wisconsin law. Another way to remember the case is to realize that Yoder is an Amish last name, so it's the case dealing with the Amish value. Alright, that's all I have for y'all in today's video. Make sure you guys like the video and subscribe. And remember, keep chasing your goals, stick to your purpose, and peace out.